Okay, so good morning. Today's daf is daf lamed hey. We are at the two dots, three lines up from the bottom of lamed dal and amabet. And we introduced yesterday the concept of kol da'olim gvar, that whoever is the strongest one, that's the person who is going to win. And we didn't really discuss sort of what that situation is. It doesn't really get explained in the Gemara. The Gemara is going, and so the Rishonim debate whether it means that there's a one-time effective fight and then that's it, and whoever wins is the winner, or is it that it's a continuing situation where the uncertainty remains? Also, there's a debate whether the victor is viewed, and these can be tied together, is the victor viewed as somebody who is the rightful owner, or is the victor just viewed as the owner at this moment? Part of this is about the fact that it seems clear, as we'll see, that if in fact one of them were to bring good proofs, that we would in fact follow that. So, but before we do that, I wanted to mention, because it wasn't clear sort of what was the end result of the case that we talked about at the beginning of yesterday. So again, remember that the case that we were talking about at the beginning of yesterday, Stan wonders why I'm on his property. I say that I bought it from him and I have a chazaka, and James is my witness that I've been there for 3 years, but unfortunately I only have James. I don't have, Ken doesn't remember. And so as a result, I've only got one witness. And so now the question is what happens? So the Rambam rules as follows, that in fact, in this situation, that there will be two rabbinic oaths. And this relates to what we talked about yesterday, is why don't we have some additional oaths, and that will allow people to do things. So the first oath is that Stan would swear that in fact he never sold his field. And if he swears that he never sold his field, so then I'm going to have to give up the field, notwithstanding the fact that I've got James as my witness. And then I swear that I don't owe Stan anything because of the produce that I consumed. And again, if I swear, then I won't owe, and that will conclude the case. And so both oaths are what's referred to as a shvuat hesed, which is a rabbinic required oath. And so that's sort of how the Rambam paskins in this case.
You're almost better off not bringing no witness.
I'm almost better off. Well, if I don't bring a witness,
you give back the land, you keep the payroll, same thing, but just no swearing.
That's correct. In that situation, nobody has to swear anything. That is correct. That in some ways, both of us are better off, except that if in fact we have the proper fear of oaths, well, then if it turns out that Stan was just trying to claim it and refuses to make the oath, so then I'll get to keep the field. And on the other hand, if I was really making it all up and you and I were in cahoots, well, then I will end up having to pay him. So there is an important difference, but you're absolutely right that if in fact we are all both willing to swear, on some ways it would be better if I didn't bring you as a witness. You're absolutely right. Okay, so that's
on what basis do we require the squatter, let's say, to make an oath that he doesn't owe the payroll?
It's again both the oaths are only rabbinic. I didn't
understand it, but why should he swear? He's not entitled to the payroll. He's not entitled to the payroll.
Correct. Exactly.
So why do we allow him to make an oath that he doesn't have to give them?
No, because remember, I am claiming that I have the ein chazaka she'ein ima taina, that if you have a chazaka that doesn't also have a claim, that's not a chazaka. And so as a result, I have to have had a claim. My claim was that I bought it from Stan. And so as a result, that effectively, when I swear that I don't owe him the produce, I am swearing that that it was mine and that I bought it. Now, why don't I swear that I actually bought it and get to keep it? Because then my oath would directly contradict the oath that Stan is making, and we never let two people swear to things that are directly contradictory. So as a result, according to the Rambam, we're going to have Stan swear that he never sold the field and he gets to take the field, and then I swear that the fruit belonged to me and I don't have to pay for the fruit. Now, why should I potentially have to pay for the fruit? Because I've got one witness who says that I ate the fruit, and I admit that I ate the fruit. And so I don't have amigo because I have the one witness. And so as a result, I need to swear. Otherwise, I would potentially owe Stan for the fruit during the time that I ate. So that's the quick review. And now let's go back on to
Yeah, but you agree that you ate the fruit, though.
What?
You agree. You
I
agree
agree
that you
that I
ate
ate
the
the fruit.
fruit.
That's
So-
why I have to make the oath. Otherwise, I would have to pay for the fruit. Exactly. Because maybe, again, that's the question. Maybe I really am I'm the real owner. Or maybe I'm in cahoots with James and we actually
Well, I don't know if you're the real owner, but you're the squatter, and you have a chazaka to it. So it makes you
Right,
the
but
owner. Makes you
no,
by
no,
de
but that's
facto.
the whole point of a chazaka.
Makes you de facto owner.
The whole point of
You
the
never
chazaka.
bought it, but de facto that you
No. That the key is that if I don't say that I bought it, I don't win.
Oh, okay, right.
Right. So I have to
Right.
have a legitimate claim that's
Mhm.
associated with
Right.
it. Okay. All right. So let's go back. Now we're back on to Lamed Dalet at the bottom, 2 dots. Zeh Omer Shalavosai, v'zeh Shar Omer Shalavosai. Both two people, again, will be Stan and me, will claim that it belonged to our ancestors. Now, we neither of us have any definitive proof. It could be that we both have the same exact witnesses to the same exact thing. But the bottom line is that the easiest way is just assume that neither of us have any witnesses. So, Amar of Nachman, Kol Alam Gvar. In that situation, just as we saw at the end of yesterday with respect to the boat, so too with respect to the real property, we will say that whoever's the stronger, that's the one who prevails.
Isn't it obvious? I mean, what does that teach us? That whoever is stronger obviously wins the case. The stronger case.
No, the stronger case wins the case, but here it's true might. I mean, that of course that's actually part of the question of what is the true meaning of Kol Dalam Gvar. Is it really a wrestling match, or is it that you try and bring additional proofs? Unclear, but the point is that the simple understanding is it's a wrestling match. That whoever is the stronger one is the one who's going to be the winner. No, well, again, it's important to understand, and we'll see. We'll yeah, but we'll have the opportunity to see that really what this is about is that we don't want the court doesn't want to make a decision, get new facts, and then have to change its decision. Mm-hmm. That's really what this is fundamentally about. And because of the situation, there's no reason to assume that one of us won't eventually be able to prove something. Remember, in this particular instance, neither of us can, neither of us can even prove that our ancestors were there. Even though we're both claiming that our ancestors that were there. So again, the point is that hopefully, eventually, somebody will bring proof, and it's just not. We're not ready to decide the case, and we don't want to. Again, the rabbis, based in part on the Zilusa de Beidina concept, we don't want even if we don't generally worry about Zilusa de Beidina, which is the disgrace of the court in reaching one decision and then coming out in a reversing decision, even if we don't truly worry about it in an ordinary case, here there's something about this case that we think that there's a possibility. And that's exactly what the Gemara is going to discuss right now, because we're going to have two challenges. Okay.
Sounds like wrestling for a parking space in New York City.
100%. So we're going to now have two challenges to this statement of Rav Nachman. So let's challenge number one. Umay Shna, why is this different? So Mishnei Shtaros Hayotzim Biyom Echad, when you have two contracts that are issued on the same day. So Rashbam tells us in very good detail what the situation is. Umay Shna Mishnei Shtaros Hayotzim. If we take a look at the last Rashbam, third line from the very bottom, Lifanenu are in front of us. these two contracts are in front of us. Al Sadeh Echad, on one field, Shel Reuven, that belonged to Reuven. Shekasav Shtar Matana LeShimon, Ushtar Matana LeLevi. He wrote two contracts, one for Shimon, one for Levi. Ushneim b'yom echad, and both of them are dated on the same day. V'nimtza she'ein zem muchsak yoter mizeh, that neither of them has a greater claim. Klal, because of the general rule, v'afilu at all. V'afilu nisbarer sheshimon b'shachar v'levi v'acharav be'erev. Even if it turns out that we can prove that Shimon's contract was written in the morning and Levi's contract was written in the evening, Ain, as we turn to Lamed Hey Amud Aleph, Ain Hakadama Bishos. We say that there's no hours on a contract won't affect us. Ela Yerushalayim, only in Yerushalayim. Kedamrin b'Ksubas, as we had the case in Ksubas, Gabi Hahu Uvda, with a particular case, De'imi de Rami Bar Chama B'Tzafra, that the mother of Rami Bar Chama, Kasvinu Lenichse, that she wrote her possessions to Rami Bar Chama in the morning. L'Rami Bar Chama, Uveramasa, and in the evening, Kataftinu, she wrote them Lamar Ukva Bar Chama, to Mar Ukva Bar Chama. Ukme, and in the end, she wrote. We set it up. Biyad Mar Ukva. The Aleph changes it to Mar Ukva. Abal Pisha Hu Akron. Even though he was the latter one, we ended up giving it to Mar Ukva. Umishum Hai Taima, and it's because of this reason. Atu Birushalayim, outside of Yerushalayim, Yatve de Kosvin shows where they write the hours, that we don't follow the hours. The Kavan Shalo Perishlo Ruvain Lashimon Hasha, since it wasn't written the specific hour, Nimtza Shalo Ziko, because of Zeh. Ad ha'arav, they don't get the possession until the evening. Ho'el v'lonis parishbo shas shachris v'nimtza shneim shavim, and so as a result, the two contracts are considered equal. And so as a result, if you don't actually write the hour in the contract, then it's not meaningful. Okay, so now that we, so we have why. Now, what is the law in that situation? Well, that's we turn to the top of Lamed Hey Amud Aleph.
Why does he get the last one get it if they're equal?
Well, again, that's what was the decision in that case. We'd have to go back to Ksuvas to understand why in that case. But let's take a look and see, right? Rav Amar Yachloku. Rav says that in that situation you divide it. Ushmul Amar Shuda Dedaine. It's the judge's discretion. Now, what exactly does the judge's discretion mean? We'll see in a moment that it really means that, at least according to the Rashbam, it means that they evaluate who's got the best argument, and we try to ascertain what the possible truth is. So Hasam Leika Lamekam Allah Demilsa, that so now so again the question is why in that situation do we have a machlokas of Rav and Shmuel where neither of them say Kol Da'alam Gvar? And yet, in our situation, Rav Nachman says Kol Da'alam Gvar. So how come Rav Nachman doesn't follow either Rav or Shmuel? Well, Hasam Leika Lamekam Allah Demilsa. There's nothing more to ascertain. We know the facts. We know that that they were both written on the same day. Hacha Ika Lamekam Allah Demilsa. But here, there's a lot of evidence that can still come to the court, and so as a result, we're not going to reach the decision. As Rashbam says in Hasam, 1, 2, 3, 5 lines down in the wider lines at the in the lower wider lines of the Rashbam, the Beis Shtaros, when you have two contracts, Leika Lamekam Allah Demilsa, there's nothing more to figure out. Hayom Olamachar, whether today or tomorrow, Sheyevi ha'echad edim v'yitol, that would allow one of them to take witnesses and take the property. Sharei hashtaros shavin, because the contracts are identical. Bismanan, with respect to their time. Va'afilu im yavo edim v'ya'idu ze nechtav v'nimser b'boker v'ze be'erev halo ein hakdama b'shos. We don't care about the timing. Kamosha pirashnu, as we explained. Lamala, above. V'leika l'meimar shema zen nimsar tchila yom o yomayim o chodesh v'achar kach nimsar hasheni. And we won't say we're not really concerned about the fact that one was given ahead of time and the other one was given a day or 2 days or a month later. Lashani. Because once they were written on the same day, we can assume that they were given on the same day. As is implied by the language of the contract itself. Hilkach, Rav Amar Cholkim, Rav says you just go ahead and divide because we can't determine. Ushmuel Amar Shuda Dedaini. We figure out the best of the court decides. Of the Hoel, the Ein Levarer Olam, since there's no possibility of clarifying it ever, Hadin im Misha Mishtadlin Beitin Bedinan Vidananoto, that whoever has done the best in their efforts to convince the court, that's who we follow. Aval Hacha, in this case, Bahai Karka, Deleka Loshtar, Velo Edi Chazaka, it changes the Bach changes Edim to Edi Chazaka. Ve'ika lamekam Allah de Milsa, im yavou v'yeidu shall mihu, and it's possible that you could have witnesses come and tell us who it belongs to. Hilgach ein kan lomar chaloka. We won't say to divide it, v'shuda, or decide it. D'shema yavo edim v'yisteru esadin shadano based in. Because maybe the witnesses will come and contradict what the Beis Din decided. Hilkach ain't based in his kukin. We're not going to give based in the power. Lahem ladun din shesofo lavoli de ivut elaminichim osan v'kol de alim gvar. We're going to say that whoever is the strongest will prevail because we don't want the court to reach a decision and have it reversed. Until the witnesses come and they clarify it. So that is, again, that's question number one, and that's the explanation. So when you have the
why is the case with Rav and Shmuel, Adim could come next week or next year?
What are they going to testify to?
What's the difference between that case and this case?
The case is that there's no more additional facts that can be determined. Here, we have no witnesses that say whether it was Stan's ancestors or my ancestors. We have no witnesses about any contract going in either direction. All of that is possible to have because in general, you have witnesses on deeds.
So in the other case with Rav and Shmuel, you want to say everybody has already brought all the evidence, the witnesses and so forth, and there's nothing else, no more evidence.
Well, the point is that what evidence could there be? Meaning neither of one of them can say, well, I got mine first. That doesn't matter because the hours don't count outside of Yerushalayim. And neither of them can say that, I'm a better friend. That doesn't matter. So the point is that there is nothing left. The contracts themselves have been defined. And so as a result, there's nothing left to prove. There's no additional witnesses who could come, even theoretically. The only possibility, which the Rashbam therefore rejects, is the possibility that in fact there was some kind of fraud and that even though one contract was written on a particular date, it really wasn't given until a much later date. But that we don't assume that's the case. And so as a result, we can reach a decision in that case.
Could witnesses come and say they overheard a scheme that this second contract's for fraud?
Yes, but we're assuming the issue is that we are on some level, we're assuming that that both contracts have been validated. So so that doesn't seem to be, again, theoretically, yes. But from a practical standpoint, we're not going to worry about it because we've gotten all the information out of the contract that we can. To the extent that, one could even argue that case is talking about where it's the same witnesses. And so, yes, we testified to both, meaning how did he do it? I have no idea. But the bottom line is that we don't have, it seems clear from exactly what the Gemara is telling us that there is no way to further clarify anything. There is nothing left to testify. So that's the reason that we're going to go in that direction. So now we ask our second question. Umayshna mahaditanan. So all right. So back in the Gemara. Sorry. So now third line, middle of the line, fourth word from the end. Umayshna mahaditanan hamachliv para b'chamor v'yalda Now we saw this case. This is a case in the Mishnah in Bava Metzia, Daf Kuf Amud Aleph, that we had somebody who exchanged their cow for a donkey, and it had a baby. V'chein hamocher v'yalda, and it had a child. V'chein hamocher shivchaso v'yalda, and similarly, somebody who sold their slave, and the slave had a baby. Zeomer ad shalom macharti yalda. The one who says that was the seller says that it's the birth the birth happened before I sold it. Zeomer shalakachti yalda, and the other one says that it was afterwards. Yachloku. So as a result, they're going to divide. Now, Rashbam will help us here also understand the choice of language in this case. So we're going to look at Umaishna, Vav Mem Shin, the last word on the line. It's about 15 lines down in the Rashbam. Umaishna Had Rav Nachman Mimachlif Parav B'Chamor. Why is Rav Nachman's decision? Okay. I'm sorry. Did I don't think I gave. So Yachloku. The point is that the Mishnah ends in that situation where we divide the value of the child because we have no basis to say which way to go, and so as a result, we divide the value of the child. So Rashbam asks, "What's the question that we're asking?" The question is what's the difference between Rav Nachman's case, from the case of the trading a cow for a donkey? The Kavan now here Rashbam is going to explain to us why we use the language of machlif when it comes to the cow and the donkey, and mocher when it comes to the slave. Machlif means to exchange. Chalipin, it's a different kind of contract, and mocher means to sell. Now, and so as a result, we're going to he's going to explain that for us. The Kavan shemashach bal hapara es hachamor. The point is that when the owner of the cow pulls towards him the donkey, wherever the cow is located, niknes hapara lebal hachamor. Wherever that cow is located, the owner of the donkey now owns the cow. So that's a very important fact, that when we do a kinyan chalipin, if I trade you my laptop for your tefillin or something like that, so then as soon as you get my laptop, I get the tefillin. Or as soon as I take the tefillin, you get the laptop. So b'chol makom shehi, wherever it is, demetaltalin, because it is a movable property. And when it comes to movable property, niknin b'chalipin, you can acquire it with the concept of an exchange. Kidiknan b'kshushin, as we saw in Maseches Kedushin, kol hanase damim ba'achar kevan shezacha zeh nischayev zeh b'chalipin. That whenever you make something into the payment, when this one takes it, the other one gets the other thing. V'lekach ein hadavar yadua havlad shelmihu. As a result, because the cow was in the other room, we're trading a cow and a donkey. And when we trade the cow for the donkey for the cow, the cow gave birth, and we don't know did the trade happen before the birth or after the birth. So shaharei lo ra'adayin es paraso. The owner of the donkey hasn't seen the cow yet because the cow was in the barn. Abal b'mechira. Bedamim, if in fact, so why did we say chalifin? Because if we had said a mechira bedamim, that it was sold for money, we have the issue that money, kesev ain't a kona, that when I give you money to buy something, I don't own the item until I actually take possession of it. And the reason is the rabbis were concerned that at least that's the way we understand it. There's a debate about it, why, but the reason that we understand is the rabbis were concerned that if I don't actually get the property and you still are holding my property, but I've given you the money, you'll say, oh, it got burned up in the attic. And so as a result, in the storage. And so as a result, I'll never get it. And to prevent that kind of discussion, we basically say, even if I give you the money, the deal isn't done until I take possession.
Does that happen with Philippine also?
He
takes the donkey. And you say, oh, sorry, the cow wasn't in.
Right, but now it's clear. I own the meaning I know what I'm doing. The point is that you're absolutely right that that same potential issue could exist, but now we're making the person who is the acquiring person have the option. Meaning, if I want, I can give cash, and so as a result, I would have until I take possession. It doesn't belong to me. But if I want to take possession now, I can do chalipin. So basically it's giving the parties the option to essentially go around that rabbinic decree. So so let's go inside of bidamim. If we were doing it with money, low matzilim income, we wouldn't be able to have this case. De'ain mos kanos, money doesn't buy, doesn't cause an acquisition. The yachsaru behen, because you can go back on them. The ilu mashka lebeso, and of course, if the person actually took the cow to his house, achar matan mos, after he gave the money, sulo matzi moker, the seller will not be able to say, Lamemar, Birshusa Yalda. He won't be able to say that it was in my possession that the baby gave birth because I will have taken the cow to my home. Because it's clearly in the home of the purchaser. Hilkach nakat chalifin bechamor upara velobadamim. So that when it came to the chamor and the para, we use the language of chalipin and not money. Uperak hashoel parech the nexe bershus deman. And when we saw this in Bava Metzia, we asked, well, why don't we just check whose property the new baby is in, and kaima, and we'll have that. We'll say that that's who owns it. We'll have it ida chamotzi mechaveru olavaraya, and the other person will have to prove it. And umashani dekaime ba'agam, and we answered that we're dealing with a situation where the cow that gave birth was in the
Swamp.
marsh, in the
In the
swamps.
swamp.
And so as a result, that's why it's not in anybody's property, and therefore we will say that we split it. Umechira nakat gabi shivcha, and when it came to the slave, we use the language of sale, de'evid nikna bekesef, because when you give the money for a slave, then you would actually acquire the slave as soon as the money is given. Below Mashicha, without any Mashicha out, without any dragging. Umishinasan mos, niknas lo hashefcha b'kol makom shehi, that wherever she is, she's acquired. Behilkach ein yadua b'rishus mi yalda shaharei lo ro ta halokeach b'shas matan mos, because she wasn't visible at the time that the money was being given. So yachloku, so they divide it. So hasam, so now we answer the Gemara's question. So again, why over here in the case of the cow and the donkey, or the case of the maidservant, we're going to split it, and in the case of our case, we're not going to split it. So the hasam lahai, as we turn to Lamed Hey Amid Bet, Islay Drara de Mamona. In one case, there's a clear claim to the money. Ulahu Islay Drara de Mamona. That in one case, both of them have a clear claim to the money. So let's take a look at the Rashbam. Let's just finish the line. But hacha idamar lo damar, v'idamar lo damar. But in our case, either it belongs to me or it belongs to Stan. Meaning that in the case of the sale, we'll see this inside the Rashbam, but I'll do it outside first. In the case of the para, in that animal belonged to each of us. So as a result, maybe it was mine, maybe it was Stan's. But when it came to the property, both of us are claiming that it was our ancestral land. We're effectively claiming it never belonged to the other person. And so as a result, therefore, it was, if it was either mine or it was his. So in that situation, we don't want to allow for a split because we both don't have a good claim.
It's possible it's neither of these.
Well, that's true too, but the bottom line is that it's
Opposed to the cow.
Okay, but as opposed to the cow, exactly. So let's take a look. Hasam, back in Rashbam, with the about 12 lines up in the Rashbam on the bottom of Lamed Hey Amid Aleph. Hasam gabi hamachlif paralach b'chamor. When it came to this trading of the cow and the donkey, the tarvayu islahu drara de mamona. Both of them have a claim to the money. Shapara v'hashivcha shel shneim haisa, because obviously the cow and the maidservant were owned by both of them. One after the other. And both of them are claiming that the baby happened when they were when it was under their ownership. Inami b'shas chalipin yalda, or even at the moment of chalipin it happened. Ve'ein lebarer shel mi. If it happened at exactly the moment in the middle, right? There's no way to clarify who it belonged to, and as a result, we have completely equal claims. Shel mi havi havlad, who belongs to who the child belongs to. Hilkach yakloku, and so in that situation we divide. Now, what about that whole concept of shuda dedaina, where the court gets to decide? It does. Maybe this can be used to contradict Shmuel. In this case, there's no possibility of saying that the judges should follow sort of who has the best evidence. Afil l'Shmuel, even according to Shmuel, delo shayach l'meimar, because it's not applicable. Ela gabi matana l'shnayim sheyiru, based in l'mi ohev yoter. Because when you have a situation of a gift, so then the court can investigate. Who did the giver like better? And so as a result, maybe that's who it intended to give it to. Diladi day gamar umikne, that's the one who he really intended to give it to. Aval hacha b'derav Nachman, but now when it came to our Rav Nachman case, shezeh omer shalavosai, when it came to that situation, continuing in the Rashbam, idamar lo damar. If it belonged to one, it didn't belong to the other. So, and we'll just read the first few words of this next Rashbam. Lo haisa karka shel idach meolam. They're each saying that the other one never owned the property. And so as a result, therefore, we've distinguished these two cases, and we've explained why, again, kol da'olam gvar applies. And again, the principle that we began with, that I outlined outside, is a principle that we end with, which is that when we have a situation where we don't have the possibility of figuring out what the facts are, where we don't have the possibility of figuring out what the facts are, so that'll be where we're going to say to split it. But when we have the possibility that either of them can bring witnesses, and there's no reason why they don't have witnesses now, it just so happens that they don't have witnesses now, that's where we're going to say kol da'olam gvar. Whoever is the strongest will prevail in that case, because we know that eventually somebody's going to bring witnesses, and at that point in time, we're going to get it to the right person. Okay, so Amri Nahar Dai.
But aren't we talking about now, called the Alim Devar? That he's taking, this person can take it now, we're not going to wait?
We're not going to wait. That's correct. That's what Kolam Da'alam Gvar. We're going to allow them to fight it out, and the court is not going to get involved because the court will eventually get involved. The court wants to get involved when it actually can make a difference. Right now, there's nothing to say. And so as a result, now, of course, I will note that it is possible that the two people can come together and come to an agreement and figure something out. That's the hope, obviously. Okay.
And if one of them takes it now, based on call
Alim Gvar, yes,
call Alim Devar, then 2 years later they bring evidence, someone that one is really more entitled than the other, and the first one says, "No, I don't care what evidence you have. I'm keeping this property."
Well, that's when the court will get involved, right? So then the court will get involved, and not only will the court get involved and say that you have to give the property, but all the fruit that the person ate during those 2 years, that fruit will be given away. Will have to be paid for. And even if the person, quote unquote, got a chazaka, the fact that it was a kol da'olam gvar case, the Beis Din will know that there's no chazaka associated with it as well, because you can't get the chazaka after you have the kol da'olam gvar. So you could only get the chazaka by bringing witnesses from before the kol da'olam gvar moment. So that would be exactly. So we would take it away from the person. So there is, and the point is that we're dealing with real estate, and that's the easiest case to talk about. And the beauty of real estate is that it lives forever. And so as a result, we're going to enable the person to get the property back. There's not a concern. I mean, there's some concern of wasting. You can dig holes in it, etc. But the bottom line is we're going to say that there's no real issue with respect to to that, we can get we don't have to rush to a decision.
So until the court gets involved, it would be a two-state solution.
A two-state solution, correct? Yeah, something like that. An armed two-state solution. Okay. If somebody comes from the marketplace, so again, Stan and I were arguing about the property, and now James comes in and he grabs it. Ain motzian osam yado. The Nahardaim say we won't take it away from James, because the truth is we don't know who to give it to. We can't take it away from James and then put it up for grabs again, because again, we saw yesterday that that the Beis Din should not take it, and if they take it, they can't give it to anybody. So as a result, the Nahardaim say that basically some third party can come in.
What happens with the donkey?
The donkey case, we split the baby. We split the baby. We don't actually cut the baby in half. We split the value of the baby. But in this case, where both Stan and I are claiming the same field, and James comes in and takes it, so James is going to get to hold it until one of us comes with evidence. Now, if in fact we were to come together and say, hey, let's agree and we'll split it, etc., and we come together and we say that we're both owners, well, then we can have the court decide. But if we're still fighting about it, then the court is not going to say. The Tani Rabbi Chia, Gazlan shel Rabim lav shmei Gazlan. That according to Rabbi Chia, we have a brisa that says that somebody who steals from the public is not considered a robber. Now, clearly, and the Rashbam explains that what we're talking about here, we're going to understand this. Let's take a look in the Rashbam, last of the wide lines at the top of the Rashbam on Lamed Hayim and Bet. The Tani Rabbi Chia Gazlan shel Rabim, the Savri Nahardai, the Nahardai understand the Begazlan ki hai Myri, that the thief in this case should guzzle mishnayim hachalukim bedavar bedavar zeh. Bedavar. Zeomer shalihu, v'zeomer shali. That what we're saying when we say the public, we don't literally mean that you steal from you steal apples off the apple tree that's in the middle of the square that everybody owns. No, we're talking about a situation where exactly our situation, where James comes in and steals something that Stan and I are arguing about. Rav Ashi says no. La'olam shmei Gazlan. No, that person is considered a thief. Umay lo shmei Gazlan. What did Rabbi Chia mean in that situation? Shelo nitan lehishavon. What he meant is that it's not easy to restore it. As Rashbam explains, Umay lo shmei Gazlan. De ka'amar Rabbi Chia. This is now 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines down in the narrow lines of the Rashbam. Umay lo shmei Gazlan. What did the Rabbi Chia mean when he said he's not called a Gazlan? De ka'amar Rabbi Chia, that when Rabbi Chia said that, lo lahakel alav Patro Milashalim, it wasn't in order to make things better for the thief, in order to make him exempt from paying, but rather his point was to make things more difficult for him. That it's not possible to restore it. Lo mitchaper. The Bach changes that word to Bahashava, and there's no atonement in returning it. Because he doesn't know to whom to return it to. After it came to his hands, he has an obligation to return it. James would have an obligation in that situation to return the property to the proper owner, but and not to let it go out from his hand, and to let them, the two original owners, argue about it. V'chol man da'alim mishneihem is the Dalet adds the word mishneihem gavar, that whoever from the two of them is stronger, we don't allow that. As we ruled earlier, as we just said yesterday, that if the Beis Din takes it, they're not going to allow it to go because they can't return it to the wrong person. Certainly in the case where somebody has some theft that comes into their hand. He has to give it away, but he doesn't know to whom to give it. When we said in the parak Mocher es Asfina, as we'll see in a few weeks, I guess, Amar Rabbi Levi, Kasha Onshin Shal Midos, Me Onshin Shal Arayos, that actually the level of punishment that one has for doing false weights is worse than the punishment for immorality. Umefarish hasam efshar b'tshuva v'hacha lo efshar b'tshuva, and the reason is because when it comes to immorality, you can ask God for forgiveness and you can avoid doing the sin again and therefore get forgiveness. But when it comes to hamocher b'mida l'rabim, but if you sell something that to the b'midar oven l'rabim, if you sell something with a false weight, a hollow weight to the public, you don't know to whom you have to go back to. You had lots of customers. You don't track them all. Valiba de Rav Ashi Iri, and according to Rav Ashi is who we're following. Nami Rabbi Chia b'mocher b'mida she'ena yishara l'rabim v'kein nira le'ena shitazu. So that's what I think is exactly what we're talking about. So the Rashbam explains that there's no possibility for tshuva. So as a result, that's that. So we have this debate with respect to the Nardaim, but the bottom line is it seems like we paskin that actually the Nardaim are correct, that if James were to come in, he would be able to hold it and we wouldn't be able to take it away from him. Now, it may still be true that as a result, he has tshuva to accomplish and he won't be able to accomplish it because he doesn't know to whom to give it. But all right. Okay.
So he says in the end, it's not correct. But Rashbam says, "B'mocher b'mida she'ena yishara l'rabim."
Yeah. That's talking about the Gemara over in on Daf Pei Bet, where we say that if you sell something with false measurements, it's going to be very hard for you to do tshuva, and that's more machmir. The halachos of midah of measurements is worse than the halachos of arayos, because you can't potentially do tshuva in connection with this case of the false measurements.
And that's why you don't call him a Gazlan?
And so exactly, we don't call him a Gazlan, not meaning that because he doesn't have to return it, but he can't return it. So that's what we mean. So it's not meant to be lenient. Again, that's according to Rav Ashi. And it seems like we actually paskin according to both of them, both the Nahardoim and Rav Ashi. We seem to say that both of them are actually correct. Okay. So our next case is chazkasan shalosh shanim miyom liyom. We said that you need a chazaka of 3 days. So
could you say that since neither one has any proof in this case, one says it's mine, one says the other, but they really have no. Could we make the stretch and say this is hefker, and that anyone from the shuk could come and take it?
Well, no, we don't go so far as to say it's hefker, because again, according to Rav Ashi, as we also paskin like him, the person who comes in is stealing if they have no claim to it. However, we can't take it away from that person because we don't know whom to give it to. So the point is that it's not quite that it's hefker, but you're right that it's like hefker in that we're not going to take it away from that person. Okay, we got to get going because I got to get to my dentist appointment. So chazkasan shalosh shanim miyom liyom. So the chazaka is 3 years every day. So Rabbi Abba idale le ihu gufei sana defere. If in fact there are witnesses that say that the person himself gave the basket. So now the question is what does that mean? La'alter havi chazaka. Then earlier he'll have a chazaka. So let's take a look in Rashbam. Rashbam gives us one interpretation, and we're going to go with that interpretation. Im yesh edim, so top of the wide lines, of the middle wide lines in the Rashbam. Im yesh edim shehigbia hama'arer, that if Stan, who's making the claim away from me of the land, if we have witnesses that see that Stan, sana de peri mikarkazu al ksafav shelzeh, that Stan helps load fruit from the field onto my shoulders, hamachzik shetoin lekuchahi, then the one who claimed that it was something that he purchased it, namely I claimed that I purchased it, biyadai ma'achar shesiyalo. So after he's now helped me, laholich haperos lebeto, to take the fruit to my to my home. Shuv ein yachol liton. Now we're not going to let Stan any longer claim velomar lo macharti lo, that I didn't sell it to him. Shalo hayalo luciayo belakitas aperos, because he shouldn't have helped me with the gathering of my fruit. Ella hayalo limchot. He should have complained. Umedisayeya lo, and because he helped me, it's as if Stan admitted that he sold it to me. However, Amar Zvid back in the Gemara. So this is 1, 2, 3, 4, 9 lines down, 8 lines down in the Gemara. 9 lines down, excuse me, in the Gemara. Amar Zvid, ve'im ton ve'amar leperos horadtiv. However, he comes and he says that he gave me that he had sold me the fruit and that really I was his sharecropper, well then Naaman, then he is going to be believed. V'hani mili b'toch shalosh, but that's only when it's within 3 years that this all happened. Aval achar shalosh shlo. But if once I get a chazaka and he then tries to use that excuse, no, sorry, Charlie, that's not going to work. Amrle Rav Ashi Rav Kahana, ila peri achte. If in fact, so now Rav Ashi is wondering a good question. If in fact, what if I do? What if Stan does set me up as a sharecropper? My havalei lemebad. What is he supposed to do? Because now, after 3 years of serving as Stan's sharecropper, don't I get a chazaka? So Amrle, Rav Kahana provides the very clear answer. He has to complain. That's the key. You need to protest during the first 3 years. You need to make it clear that I am your sharecropper and not a purchaser. Because if you don't say that, so Hani Mashkanta Desura, when you comes to the Mashkanta Desura situation, and the Rashbam helps us remind us what this Mashkanta Desura situation is, but given the time, I'll do it outside. The Mashkanta Desura situation is, I lend money to Stan. I lend him $1,000. He has a field that produces $100 of produce a year. So I take the field and I say that every year that I'm on the field, you owe me $100 less. And it's essentially I take by avoiding paying rental fees to Stan, I use the loan that I gave him to pay for the rental fees. Now, the magic of this is that it doesn't violate ribis prohibitions, even though it could be that when you count up all of the produce that I end up eating, maybe we had 10 great years. And so as a result, instead of getting back just $1,000 and $100 a year, I get back $200 a year. And so I end up with more money than I started with. But because it's a fair deal, right, on some level,
The other way.
right, and as a result, it could go the other way. Rashbam says exactly that. It could be that there was poor crops, that the wind damaged the crops, and there was no crops, and I ended up with zero. It could be, depends. That's the question. So we're going to say that I ended up with the right amount. I ended up with 1,000. But the bottom line is so the rabbis allow this mashkanta desura. So the kasav behu.
So you rent, you borrow the field or you lend
No,
it?
I take the field and I lent Stan the money. Okay, the kasav behu, in that situation where we write b'mishalim shnaya ilin, that for at the end of this number of years, tepuk ara, you're going to take this land. Stan is going to take this land back below kesef without any paying of money, because my occupation of that land for those number of years will constitute the payment. Ikavish lishtar mashkanta gabe. Now, I am the one who's holding the contract of the loan, right? Because I'm the lender. So the lender holds the IOU from the borrower. So what if I were to hide that document? And now v'amar lekucha hi biyadi, and I say that I bought this land from Stan. Hachinami de mehemen, I would be believed. So mitakne rabbanan midi to asabe lidei pseida. Could the rabbis have set something up that's going to cause Stan to lose the field forever? No, of course not. Ella ibayle lemachuye. He has to complain. He has to make public during the first 3 years that I am there based on this mashkanta desura situation. So hachinami. So here too, if I were the sharecropper, he would make public in the first 3 years. He needs to protest. And
Who's
so
who's protesting?
so
Yeah.
Stan, the owner of the land, needs to protest and make clear the protest isn't David, you're on my land and you don't belong there. The protest is David, you're on my land. You belong there because you are my sharecropper, or you belong there because you lent me money. But you have to protest during those first 3 years, and that way I won't be able to get the chazaka. And I presumably you'd have to protest every 3 years, but and that way you would make sure that I don't get a chazaka. And that actually, we have that, even in a modern law today, when it comes to fences that are in the wrong place, we generally advise clients to make sure that you let the other side know that, by the way, your fence is in the wrong place. I don't really care, but at the bottom line is that know that the property line is not moving as a result of that. And so we make sure to sort of let people know in order to make clear that the situation. So that is our discussion. We finished the discussion of Kol Dam Dvar. We're back in the world of Chazaka, and we're going to, God willing, continue the discussion of Chazaka tomorrow. Again, one last point, and that is that Thursday and Friday will be by recording only. So please be sure to check out the recording. God willing, hopefully by the end of the day on Wednesday, those recordings will be up and good to go. So I wish everybody a wonderful day, and I'll see you all tomorrow, Amir Tashem, and then Thursday and Friday, I'll see you by recording. Be well.
Fair enough. Thank you.
Laura, what do you want to say?